Hello. Hello.
That is so exciting.
Good morning.
Good afternoon, people. Come on. So thank you for coming, and it is very exciting to actually try to teach myself something, because you probably know everything what I know by now, maybe even more. But I think since we are being recorded, was the button pressed?
I didn't press the button.
Hold on.
Take two.
It is. So since we're being recorded, I am going to go and start with some basics for the future generation that hopefully will come and help us in this new area of law named Raise the Age. And so please bear with me if I am saying some law school 101 that you're like, wow, why are you here? You know, I've done it 10,000 times already. But what I would like to do is to point out what I believe is been going on and how this law has been developing since October of 2018. What I also did is I contacted Judge Carter's chambers and asked him to share with me every single decision he issued in Erie County Court since October 2018. I saw probably two from Joe. There are a couple mine, my cases, couple Dean Paleos. I am not sure if I saw Nora on those, but as of now, I have, I believe, 8 decisions that Judge Carter issued in writing. There are actually 2 more. Both of them are my cases. He orally pronounced that from the bench last week, so I can tell you about what his decisions were. And Judge Carter's chambers told me that those will be published in the next couple of weeks. So for now, we're gonna go, like I said, I'll start with the basics, though I'm sure each and every one of you who sit here today, you know what those basics are. This is more of the CLE for whomever is going to join the panel in the future, but we're gonna focus on the developments in the Raise the Age. It's very exciting to be part of this new law because we can actually create it. And even in Erie County, I can tell you how Judge Carter, reading the cases that he's done, that he's changing a little bit, especially in the issues of extraordinary circumstances. So let me try to use this modern technology. So we know that the legislation was signed into law and came in effect October 1st, 2018 for the 16-year-olds and October 2019, 17-year-olds. Just a brief remark about that. The Raise the Age is related only to the felony level offenses. So any misdemeanor level offense for 18 and 17-year-old will be now or is now a juvenile delinquent and is treated as any normal juvenile delinquent proceeding as prior to Raise the Age legislation. So when we talk about Raise the Age, we only talking about felony level offenses. There are questions about VTLs and et cetera, VTLs in Erie County has been decided if there is a felony that has traffic tickets and unlicensed operations, 509s, they going to be put together as a packet to go to youth BART, but I have a matter right now that the felony is now being transferred to family court. What happens to VTL? So they're being kicked back to Buffalo City Court. So you have to know that, and it was not at the beginning. At the beginning, they would keep the VTLs in local jurisdictions. They would take the felony level offense. But lately, I do not know if it was through OCAs, if it's just a policy, but I have seen cases in Erie County that if the felony level offense has VTLs attached to that, Judge Carter or Youth BART has taken all of them And then if the case is removed to family court, VTLs will get a separate date to the local jurisdiction. In my case, it was City of Buffalo. So what you need to tell your client, though you represent them assigned on all of the matters, if the felony offense being moved to family court by Judge Carter, you need to advise your client that they will receive a notice to appear in Buffalo City Court. As you know, on the traffic tickets, there is a date of appearance that is listed. If it's part of the raise the age matter, that date is not going to occur because that is going to be transferred to youth part. So it's a little bit of a complication. What do you tell your client? Okay, my case is now family court JD matter or sent to adjustment. So with the new bail reform, you tell your client, you wait until you receive a notice to appear in a city court or a town court or Cheektowaga or Hamburg, whenever the case was originated. So the terms. We're operating different terms now. They're complicated. To me, with my language barrier, it was really tough to figure that one out. So we have AOs. AOs are 16 and now 17-year-olds who are charged with a felony level offense. We have JOs, juvenile offenders. Those remain the same as per prior JO. And you know my love of law, right? So JO statute is not touched by raise the age law. And those are 13-year-olds who committed, and 13, 14, 15-year-olds who committed designated felony offenses. I'm not going to list all of them. You all who done criminal work, you know those are homicides, rapes, and most heinous crimes, but all of them are listed in the statute. So JO remains the same. Here's the caveat, a little practical tip. There's still no clear indication which court should have jurisdiction over JO. Is it going to be youth part or is it going to be family court?
I have one right now.
I have one too in front of Carter.
I have one in front of Friedman. So I guess it's however they decide to file. I have a rape by forcible compulsion and it's in front of Friedman. 13.
Yeah.
So what I'm saying is I am sure that will be some litigation over that issue. I'm sure probably not going to be us because if my client is charged with rape and he's in front of Judge Friedman, I'm not going to complain about it. But what I'm saying is that is a very interesting issue because I have not raised it because I don't want my case to go to criminal matter, to youth part. I would rather have my client not to face any possible criminal conviction. But what I'm saying is watch for that because I think there will be some litigation on that issue.
Yeah. Because it would normally go to county court on the qualifying offenses.
The
So you
raise
think
the
it would go to what?
I agree, but I've seen them filing in family court on the JOs and they have not been rejected in every count. So I'm just saying practical tips, guys. And the last one, youthful offender status. So youthful offender status is the same, statute remains the same. It's applicable in criminal court youth part, just like it was in county court before. So AO 16, 17 charged with felonies, JOs 13 and up charged with designated felony offenses, and youthful offender status is the status that is defined in Article 720 criminal procedure law that replaces a criminal conviction with certain conditions. So those are terms that we need to be familiar with. And juvenile delinquent, now we know those would be the felony levels, not JOs, felony levels up until 16th birthday. Then from 16 and 17, misdemeanors, and the cases that are transferred from youth part either by consent of the parties or pursuant to 722-23 subsection 1 of criminal procedure law. Please stop me like you do if you have any questions. So it just, once again, defines all those terms for you guys. The presentation, as you see, is published on New York website. So if you type or Google New York State raise the age, this very PowerPoint presentation pops up, and you can take a look at your leisure. Okay, now if case comes as a AO, adolescent offender, or raise the age kid, the governing law is Article 722 of Criminal Procedure Law, and it does state that any youth that comes through AO has to have an opportunity to be presented with volunteer services from Department of Probation. And for us as defense bar, it does create a number of issues. Let me take a step back. I am not here to defend this legislation. It's something that we can work with. I do think there are some deficiencies in there, but it's not my position, or I have no power to say or state my opinion. As a defense counsel, I believe that we take a law as it is. We develop and create issues that may be ripe for new legislature, or for some review by higher courts. And the statute that states that the probation department must meet, it's not may, it's shall see the youth to offer volunteer services through Department of Probation. And the statute follows to say that the judge cannot use that against or in favor of this youth when deciding a form of release. Sounds really great, but what it does, it tells probation that they have no option but to sit down with the family and offer services. The most bothering language in that statute for me, maybe not for you guys, is that it says that anything that youth says in this wonderful interview where they shall offer services cannot be used against this youth. We all know that the only privileged communication is between you and your client. And though I agree that the probation, when they report or send the report to Judge Carter or whomever, the presiding judges, they're not going to say this youth said they used a revolver, while robbing somebody. What happens if the probation department now prepares PSI? To me, and the statute says nothing this youth says pertaining to the matter shall be used against this youth, but every single PSI that I've seen contains all the information about substance use, which we know one of the factors when judge makes a decision for sentencing. So when I won't name names, but when there was an original probation interview and the probation officer keep repeating the word that right in the statute, what I would go, when I first meet with this client and the family, I would say, you have a right to remain silent. Please exercise your constitutional right. Because we say that, and then the probation officer comes 3 seconds later and say, you can tell me everything, I'm not going to tell the judge what you're telling me. It is so confusing. We have a 16, 17-year-olds, 15-year-olds under JOs. it's confusing to me. If you ask me as a defense counsel who's been doing it for years and years, what does that mean? I don't know. So it's a case by case basis. And though Judge Carter would say from the bench, I am not going to use that, and I don't think he did. I do believe we're lucky enough to have a judge who reads the law and in good faith follows what he believes the law is. But many of you, Joe, Nora, I don't know, Hope, if you had any cases, when you argue adjustment versus removal to family court, what did Judge do? Judge looked at the probation report and said, well, you've not been in compliance with these services. Why would I give you a break? And then I'm like, you know, but I've seen Judge do it again and again and again. So now I'm standing out and I'm like, Judge, look at the probation report. My client is in compliance, thinking, oh my God, it's such a violation of that statute that I just read. But I can see that our judge is taking that into consideration. So I would be very careful if you ask me, so what's the answer? I don't know. That's the beginning of the litigation. That's what I'm saying. Think about it. Think about it in a case that you may ask a judge to redact something from PSI that can be used against your client. So this is for your sort of way of create new litigation when it's necessary. I use it for my clients when it benefits my clients. When it doesn't, I usually say, Judge, remember, you shouldn't be using that. And so that's that. So we met with probation. They said to our clients, hey, you know, we're going to offer you the services. They're volunteer. You can stop them at any time. But what happens if your client is not in compliance and judge is looking at that report? What did judge say? You know I have power to put you in jail because you're not doing what you're supposed to do. I've heard it a number of times from Judge Carter. So how we deal with it, that's up to you. Next, so we had the probation interview. Now, the question became, the Raise the Age legislation is very clear that the youth or the defendant has absolute right to have an attorney present at all stages of the proceedings, including arraignment. And that's different from what I believe the normal adult criminal part is. The accessible magistrate, in absence of the youth part judge, cannot arraign an AO without defense counsel. They cannot do that. I don't think it ever came up in Erie County, but watch for that. But the question becomes, if youth has that right, are we absolutely have to be present for that probation interview? Not clear for me. I don't know if you have answer to that. It does say they must offer youth and the family services, and those are must tell them about the services, shall provide them with these volunteer services, but I don't know as to us. Of course, it's always a preferred type of practicing is to sit with your client through all of the proceedings, but I don't know if it requires us to be there. I prefer to be there, so I want to hear what my client has to say. Yes?
They won't, at least in my experience, they won't meet with a youth without you there.
They will.
They will? They've
If
done
you
it?
tell them specifically, it's okay, go ahead and...
Okay,
and
all right, but I mean,
yes.
like, unless, like, without consent,
Correct.
I've never
Correct.
consented, but
Correct.
yeah, it's not like they'll sit and wait for us to get there.
That's absolutely right. But I had a number of occasions when I was finishing sentencing and they would say there's a new youth. Especially, I'll tell you the situation where I allowed that to happen. I had a client who already signed up for services and it was a new charge he was coming through. So I said, you can meet with him. We met with you guys 3 days ago.
Right.
We sat down, it's a new charge. So I can remember one specific instance when I allowed them, but they did ask me, should we wait for you or should we go ahead?
Because Officer Tiffany, I like her. She's pretty.
We're not naming names, but they will meet.
That's the only person I've ever dealt with.
Okay. Any other questions about that part? Okay, then we go and guys, I'm not gonna spend a lot of time on how the part is created, the accessible magistrates, because usually we just get the case when it's already in youth part in family court. So it talks about the VTLs. Misdemeanors cannot be removed to family court. I talked about that. Violations. Okay, so before we go to removal of JOs to family court. So we not with probation, we met with our client, met with the family. Now it's a normal criminal case. It's the biggest misunderstanding in the New York State that youth part is family court. And there was some outreach to the community through one of the public libraries, and one of the public defenders, which shocked me, stood up and said, somebody asked the question from the public, said, we heard there's a new thing for 16 and 17-year-old, they're now not being charged as adults. And the public defender practicing stood up and said, I don't know anything about it, it's family court. And I was like, oh my. So I want to be very, very clear. If case is arraigned in front of Judge Carter is a felony level offense, and we have, or JO or AO, as we defined them earlier, it is a normal criminal matter with all the procedural, all the criminal procedures apply, discovery, bail, every single statute applies. And we have something on top of that. So, two major areas that has developed, and I think ripe for some appellate review, if we get lucky to have a single case to go to appellate review, is the first area. Both of them actually has to do with a removal of the matter from youth part. So CPL 722 subsection 23 talks about removal matters to family court. And the statute, I'm going to summarize, I printed out if somebody want to look at it, but in summary it says, if the felony level offense is a violent, and we all know the violent felony offenses, I think it's CPL 70 defines violent felony offenses, is a violent felony offense, then the court shall do a reading of accusatory instrument within 6 days from the arraignment. Yes?
Can sometime be waived?
It can, and there is already a case on that issue, but
I just had one in front of Judge Carter, and he reads it as a must, this shall.
once again, you're touching upon what I'm about to say, that there are so many interesting development that we can use. But anyways, the court shall do that unless it's waived by the defense counsel. I will find you that case, I believe it's from Nassau County, where the judge said, well, if defense is waiving it, they perceive that defense concedes to one of the factors. But I don't want to jump ahead. So what is the reason for the court on violent felony? Now remember, there's a grand larceny, it's non-violent felony offense. Unauthorized use of a motor vehicle. What else? Non-violent felony offenses, and I'll tell you what Judge Carter told in the conference what we're going to do about those. But the way the statute reads, violent felony, robberies, burglaries, homicides, assaults, you name it.
Criminal possession of a weapon.
Criminal possession of a weapon,
And that one,
any violent felony, 6 days from the arraignment, the court must or shall, we'll use the statutory term, shall do the reading of accusatory instruments for the purposes. Yes, Joe?
Just, what is the reading of the accusatory?
Yeah,
instrument?
I got one at 2 o'clock, I'm
Right,
really curious.
that arraignment, why are we reading it again? I'm puzzled.
Right. For the purposes of defining, looking for three things. So they need to read the accusatory as it's typed up, any supporting deposition, any documents that people may have, to look for three things. Number one, was it any significant physical injury? And the key word is significant. Physical injury occurred during the alleged commission of a crime. Number two, did the principal display a firearm in furtherance of the crime? The two key words, and the reason why I'm pressing on those, it's because of the cases that came out. The two key words, the principal displaying a firearm, and the second key word, in furtherance of the crime. And the third one, was this crime a sexually motivated offense? Three things. Yes.
What about accomplice liability? What if the co-defendant displayed the weapon?
Hold on. So, this hearing shall occur. Now, question number one, and it will be more questions than answers. I will tell you what Carter decided in some of these cases. I'll tell you what I read from other New York County, Nassau County. Most of them comes from New York County. Is that appellate level case law? No. And in my last case, Carter said, well, thanks, Ms. Dopchik, for working and bringing me cases saying I'm wrong, but I want to do what I want to do, so thank you very much. I'm not obligated, which he's completely right. So I'm not obligated to hear what the New York County decided on this issue. I'm deciding it differently. So, their case, significant injury is not defined. We have definition in penal law of physical injury, and we have serious physical injury. But significant physical injury is not defined, and every judge who I've seen issued a decision on that very issue said, well, significant injury is not defined. But the legislature went and talked about it. So if you go back, which stupidly I did, I don't know, stupidly or not, but I went back and listened to all the debates and floor discussions and everything. And they talk about, so what is it? I can tell you now, across the New York State, fracture, every single time I see a fracture, it's a significant physical injury. I have lost one. Hold on. Joe, did you have any significant injury?
Broken orbital.
But here's the thing, Lana,
Yeah.
Because the same guy had another case of a robbery, and my argument was, because he didn't possess the gun in the robbery.
That's a
case
gun
goes-
possession. We're
that goes
talking
to
about
favorable.
injury.
but with the injury, we were alleging, and they couldn't prove it was my client who caused the injury.
Yes.
So if
I-
it says a defendant
Displayed a firearm means there's no
Two
accessory
different
liability.
issues. Two different issues according to the cases.
Yeah, but it's the same
Significant
words.
injury, two New York County cases. If you need them, reach out to, there's so many, I have like 150, so I was not gonna bring you all of them. But I think I've read about 100, I didn't read every single one. New York County says, not a sole perpetrator, unable to define the exact person who caused the injury, not enough to state that this person is caused the non-participant of a crime, significant injury. Carter does not believe in it. I think there is a case, either YL or JL. I will, can you write it down? I'll forward that to you. It's out of Monroe County, where they said, we do not care. If there are 3-4 co-defendants and the complainant sustain what we believe a fracture, everybody gets significant injury, and Carter believes it for now. So when it comes to significant injury, please litigate it. There are cases out of New York State says we can't say which one did it, not enough. There's upstate New York, including Judge Carter. I print out all of the cases. I'll give them to you. Please email them. You will see he does find that if he believes significant injury happened during the commission of the crime, everybody gets significant injury. Weapon possession is different.
So it's not a typical criminal case.
In Judge Carter, it's not, but it starts. Raymond is it. In Judge Carter's mind, and we're being recorded, I'll admit that to you. He stopped me. I was this close to concede that, okay, Judge, we have the 7/22/23/2 reading.
Because they're in the car, right?
Because my client had some other guys, and we had a felony hearing, and during the felony hearing, the complainant testifies, describes the gun, no question it was a gun, was put to his head, but we watched the video, and my client was not the one who was holding the gun.
Yeah.
And I was this close, because we just finished the felony hearing, which happens to be within 6 days, so you're doing the same thing, and I'm like, I lost felony hearing, so I'm losing this one too. And I'm like, well, Judge Pete, the defense, and he's like, wait a minute. Why don't you do some research on that? And I was like, what? Because previously he did on significant injury said, I don't care who punched the guy and caused them a broken orbiter. Fracture, significant injury, you stay in youth park.
Yeah.
So by saying, just like Joe was saying, you read the statute is identical. And then I'm thinking, well, the gun was displayed in furtherance of the crime. And why I say it's important in furtherance of the crime, because there is cases. Display of a firearm alone is not enough. It has to be in furtherance of a crime. Pay attention. Those are like little tiny details. Yes, Hope.
So Alana, just so I understand, so if any one of these three conditions are found in the context of the reading of the accusatory,
Case stays in youth park unless people consent to removal.
okay, so any one of these three, the case automatically stays.
Not automatically. People can still consent
Right, I
to
understand,
removal.
but
But for now, we don't go to the extraordinary circumstances.
Okay.
Which will,
So then you're gonna get to extraordinary circumstances.
I hope. So that's why I said, I hope I have enough time.
Okay.
So weapons are different. Pay attention. Judge Carter believes unless they can show that was your client who was holding a weapon, and it has to be a fire, not appears to be. That's another thing. If there's something hidden in the pocket and they can't describe that it was a firearm, not good enough. It has to be described in accusatory instrument as a firearm. That's number one. Number two, your client, the principal, has to be the one alleged to have that. And number three, it has to be in furtherance of a crime. So possession of a loaded firearm at the first sight would be, well, right? But if the possession is in the trunk of your vehicle, not good enough. Goes to family court unless there are extraordinary circumstances. Do you see the difference between two? It's at least in Erie County for now. And the third one, sexually motivated, there are only 2 cases out of all New York State that I've seen on that issue. It's both out of New York County. I'm not going to talk about it because I don't know if Erie County is going to follow them, what constitutes sexually motivated felony, because we actually didn't have that issue come up yet in Erie County. If you're interested, I can send you, there are only 2 cases out of an entire New York State. One court decided was enough to say it was sexually motivated crime. Another one said no, not enough. Okay, so nonviolent felony offense, Judge Carter had a meeting between us, the district attorneys, and said the way he reads the statute, he still has to put words on the record that this is a nonviolent felony offense, therefore we're not going to have a 6-day reading, and maybe we can use this term, it's called, downstate New York, they call it retention hearing. I have not heard in Erie County we call it 6-day, but if you start reading the downstate New York cases, you will see and read often and often retention hearing. So it's like, what the hell is retention hearing? And then it is the 6-day hearing. So if we want to utilize the term that New York City uses, that would be a retention hearing. So nonviolent offense, both people and defense, we agree that such reading was not necessary, because by nature of those three things, it kind of requires to be a violent felony to begin with. But we agreed, we had a little meeting, and we said, well, if we have a nonviolent felony offense, at the arraignment, we will just put something on the record, say, well, Your Honor, waiving, if that's what you meant, Joe, we're going to waive the retention hearing or the hearing pursuant to 72223 subsection 2 because it's a nonviolent crime. It seems to me that our youth part is satisfied with that for now. So if somebody has an issue come up, but that seems to be satisfactory to all the parties, and we kind of agree to do that so nobody's questioning if we ignore that stage. All right. So we had 720 retention hearing or 6-day hearing. We had it. Let's say people lost it. Judge said, not enough. One interesting case that is not here yet, but I said I had a case in Judge Carter's part with Dean, and then Nora used for him for the decision, right? Yeah. So we had a felony hearing and 2 co-defendants. I represent one. Dean has the other guy. Just funny case. So our 2 boys walking on a street, and there's a family picking up their car. The car is running on their driveway. They're trying to go to New York City. So they put their stuff in the trunk, and now the father and the son are throwing garbage in their trash can. And our clients are cutting along, as they admitted a lot of kids do, and they decide to jump in a car. So as the first guy gets into the driver's seat, my client, who was behind him trying to get in the passenger, now the owner's son, coming with an empty trash can and sees through the glass their kids getting in a car. So before my client was able to get in the car, he attacks him with a trash can. So they start a fight. The father sees the fight, father joins them, and in the middle of the fight, nobody can tell who, but father gets hit with the trash can that causes him laceration on both sides, and he was put stitches on both sides of his face. So, of course, he testifies to the felony hearing, and at the end of the felony hearing, people brought the case of AT, which I included and will email them to you, but that case included fractures. So when the people said, well, Judge, maybe we should just, do the 6-day hearing today because of the case AT, and I'm like, no, whoa. I stood up and I said, and Dean had the same cases we had from New York City, clear said stitches, one case about stitches, another case about staples, was not enough to sustain significant physical injury. So we're like, Judge, we have at least 2 cases. Can we go back and re-argue that? We come back, and for some reason, Judge decides that was no more arguments, that he has his decision ready. And he says, well, thank you very much for the cases. And I hear what New York City thinks about it, but I saw the complainant. The difference, Judge, and Nora, please correct me if I think I tried to listen to Judge very carefully. He said the difference between those and mine, because I was able to observe the complainant under oath, I saw his face, I saw the stitches, and the complainant said he still had a blurry vision and had a doctor appointment that very day. So that was the reason that the injury was not cured, but even days after, he had some complication and had a doctor appointment. But in my mind, the justification for finding significant injury The judge acknowledged, said, I know those cases exist, but I'm gonna do what I wanna do. And he defined significant injury. So, that case that didn't come out yet, Mr. Portis told me that it will be published. So we'll have it. But we have the latest judge's decision. Fracture, significant injury. Now staples, stitches, and more follow-up doctor appointments, significant injury. Think about it. Do you want to run a felony hearing? Not sure anymore. So that's something to think about. But that's where Erie County stands now on significant physical injury. There are a couple cases from Judge Carter where he did not find significant physical injury. Those are, one is laceration, I think some bruising. Yes, Hope.
So Lana, so just so I understand, if after this 6-day hearing is held and the people are not able to meet their burden with regard to these 3 conditions,
Then case proceeds as defined in CPL 722-23 subsection 1.
Section 1, which is
The youth part shall remove the case to family court.
Okay.
Unless people file a motion for extraordinary circumstances within 30 days from the arraignment. And judge counts not our arraignment, but the arraignment by accessible magistrate.
Okay.
Once
And
again,
it's really just the people arguing their perceptions and us arguing ours.
let's talk about it.
Okay, because I literally have 1 or 2 about
So
it.
if we have,
Something out here.
if we have nonviolent felony, it automatically precedes CPL 722-23 subsection 1, automatically.
I have a criminal possession of a weapon. My facts are this, very simple. 4 individuals in a car, there's 3 other co-defendants, 2 are adults, I have 1 other adolescent.
Where the
defendant.
weapon was recovered.
Recovered from the passenger side rear.
They're gonna lose the 6-day hearing, so you're gonna go to 722
They're gonna lose.
subsection 1.
Holla, okay, she already knows.
Remember,
Okay.
the weapon has to be
In furtherance of a crime.
displayed in furtherance of a crime. If the weapon is located under the car seat, in a trunk, glove compartment, in pants, in asshole, it's not displayed in furtherance of a crime. I mean,
Okay,
Yeah.
no, that's what I was gathering from what you were saying, but, yeah.
I think they will concede
Okay, they're just gonna concede. Okay.
that the case, usually the language they use, they will say, we concede that the people cannot meet their burden of proof under CPL 722-23 subsection 2. I don't, if it's C or J, one of those, and the case shall proceed under 722-23 subsection 1. So judge will say, okay, no objection, Your Honor, and then the question becomes, when is there 30 days? Then judge will start counting 30 days from the days of the arraignment, say, well, this is your date by which you're filed. Then it says the defense has to file a response of papers within 5 days, or they can ask, it says in the statute, defense can ask for reasonable time for an adjournment to respond to the motion.
He's been scheduling 7 days.
Will they let you know whether?
7 days is
30
fine.
days, 7 days, and then
And that's
another
fine, because
7.
it's allowed by the statute.
Has it been your experience that the prosecutor will let you know whether they intend to file or they're gonna
Yes.
just let it go?
Sometimes they'll say, Judge, we need more time to evaluate the case if we're filing. Sometimes they come and say, we're not filing. Sometimes they come and say, well, we are filing.
Okay.
But irrespectful, or I lost the word, but it doesn't matter what people say, judge would count 30 days, give you 7, and we'll say, let's come right before that 30-day mark to see how you guys do it. Just to check how things are. Yes, Joe.
Question.
It just dawned on me. Can you technically have an arrest, an arraignment, within 72 or 144 hours you do the felony hearing, and then 6 days for the reading or
We've
the
done it
retention
too.
hearing? So you could have a felony hearing and a retention hearing all in one
Correct.
place.
Correct. We've done all sorts of things. We've done felony hearings and then retention hearings on a separate days. Depends. I'm thinking about one particular case where the people were stating that the complainant suffered an injury, and they were saying significant injury because they claimed they had medical records. And I said, well, that's great. I've not seen them. And then what happened when medical records were provided to me, the complainant was admitted to the hospital, tested positive for every possible substance you can imagine, released from the hospital, came there in 2 days and had fractured nose. So I argued, Judge, this is awesome. Please read there. And he got all the records into chambers. And I said, how they can say that the significant injury happened as a result of the assault? So, and I think they conceded, I don't know, it was 2018, but it was very interesting time frame. So when they relied on medical records and said, Judge, the accusatory said and sustained significant injury, so they're becoming smarter, right? So they write that in the accusatory instrument, but there's no full supporting deposition to say what is it. So they said, Judge, we have medical records. And we had, and the medical records were not clear enough. Was it fracture as a result of the assault, or the fracture caused 2 days later?
Good work.
Okay, so now we're significant changes in circumstances. Let's say if people do not file, the statute is so clear and our judge understands that there will be no question. If people fail to file within 30 days, case will be removed. Unless people come to you and say, hey, I have family emergency, can you give me 3 extra days? It's up to you what you guys want to do. But I think that is pretty clear. 30 days, no motion, case goes to family court or adjustment. Let me talk about extraordinary circumstances. Was I saying extraordinary change in circumstances? I don't know.
Yes.
That's my family.
We understood.
My family court experience talking. So if people file a motion, they have to claim extraordinary circumstances. And the very case that I had in front of Judge Carter had that motion. People against TR, that was the case of Williamsville North High terroristic threat. If you remember, it was all over the news. So that was the first motion they filed. Judge denied their motion, though, was under a lot of pressure, but, Judge Carter reads the law. It's like, yes. So they filed a motion where they submitted as the accusatory instrument as an exhibit the note that was written and put at the principal's office, and a lot of statements that were saying how this school was impacted, that they had to close the entire district and remove thousands of children, and parents were in such shock, and I mean, we all understand what parents went through. But what they did not do in that particular case, they had no sworn statement of fact attached to the motion. And the statute 722 under extraordinary circumstances, 2221 subsection 1 says, such motion must have sworn statement of facts attached. As simple as that. So he did not have to go, we were so lucky that they just ignored that part of the statute because, you could argue it's kind of like not normal, right? But what I'm saying is he just, and decision is here, it's December 2018, he's saying, well guys, too bad, so sad, I have to follow the statute, didn't comply with the statute, case is going to family court.
Yeah.
Yes.
I'm sorry.
That's a difficulty I'm having. During these retention hearings or 6-day reading, a lot of hearsay is being put on the
That
record.
is not required for the 6-day hearing.
And they're putting everything in
Hundreds
there.
of the evidence.
And even the extraordinary circumstance motion. My client gave an hour confession with the detective that was recorded, but it wasn't reduced to a writing. My argument was that's all hearsay. Why are we talking about it?
Well, here's the thing. I think if you bring it to the appellate division, you will be right, because it does require a sworn statement of effect. But if your client is getting YO at the end, are you gonna take it to appellate to say no, get your client convicted, and then take it to appellate division?
He confessed to 8 robberies and burglaries, so we ended
So
up.
what I'm saying, the difficulty we have to do the best, and we're lucky that we have a judge who can actually listen and try to convince them that, hey, here's the statute. There's no sworn statement effect. It's written there. He knows about it.
It's contradictory to what the intent of the statute was.
They were better off in county court sometimes than here in family court, where they're presenting hearsay.
Do you remember what I said when I
Yeah.
began saying I'm not defending this legislature? I'm just explaining how it works as of now. It may be very different in the future. Okay, so that's one, right? First, look for the sworn statement. My last case, and I did not know it was a high-profile case until yesterday. Somebody told me, and I don't have TV, so I don't watch it, so I was not sweating arguing it, because if I knew it was such a big deal, I was probably like, whew. So I represented a young gentleman. In that case, judge already issued his decision. He did not find extraordinary circumstances yet again, but decision will come out in writing later. He pronounced it was a 40-minute decision, so they will type it up. My client lives in West Seneca, goes into community center, and writes swastikas and make all sorts of anti-Semitic hate, anti-black statements, including some numbers that has some meaning for Hitler, and it's unbelievable what this guy does. White supremacist statements, and it gets bigger and bolder. So he has those permanent markers. He goes to community center and writes them down. So he was charged with 3 felony offenses. Graffiti is on its own is a felony level offense, aggravated harassment, and hate crimes, which makes a misdemeanor E-level felony offense. So that's how it becomes a felony. So 3, and then while it's pending, he turns 18. So now they charge him with 1 more in West Seneca as an adult. And because it was publicly perceived the way it was perceived, and apparently it was all over the news, I didn't know about it, people filed a motion. Those are nonviolent, right? So we didn't have a 6-day hearing, so it proceeded to 722-23 subsection 1. They filed their motion, and I kid you not, I had exhibit JJ. So I get this motion, right? It's like 200 pages. I'm like, what is this, right? So there's literally there are pictures of everything that this guy wrote, allegedly. There are surveillance cameras showing my client walking into community center and leaving the community center. There's statement from a community center worker who says, so when they start noticing these writings on the walls, so they start watching who goes and leaves the bathroom. So they had a worker assigned, and when individual goes into bathroom and leaves, they would go and check. So when my client walked and get out, they go in, sure enough, there's writings. So they had a picture of my client and got him on camera. So one of the teachers, my client's teachers, now know from, because the pictures I'm assuming were disseminated through West Seneca High Schools as well. So she recognizes my client. And he goes to the community center, goes to bathroom, he gets out, and she's standing outside the bathroom waiting for him because she now knows. So she calls the security people, they go, and there's nothing in the bathroom, right? So, but she approaches my client and says, how dare you are what you're doing? He said, I am sorry, quote, I am sorry, but I got 100% on the test today. That's his admission, right? So they arrest my client, They take him to the police station with his grandma, and he sits there. He explains every single. There were years, what each year meant, what other numbers meant, what the swastika means, and he said, well. And the detective, it's a video tape of the interview showing him pictures. He said, I did it all without looking at him. I did it all. So they filed a motion. But there's, now they're getting smarter too. So one of the exhibits, it says, upon my personal knowledge, I am the director of the community center of West Seneca, says, it's been reported, number one, it's been reported to me, it's been reported. So my response was very simple. There's not a single sworn statement of facts. We have 85 sworn statements, but they're not factual allegations. And the only one that says, well, I saw him leaving the bathroom and when we went in, there was no writing. I'm like, Judge, come on, you know. But it was more than that. And I've done a lot of research. And what I found, and Judge Carter agreed with me, so I cannot wait for that decision to come up, because not only that we won, but I feel like it was such an excellent decision on a such high case. He did say to him, isn't that irony? You're now at my mercy asking me for the opportunity. And you're saying that we're animals, we're not people. I'm African American, you're white. I mean, it was great. But what I found, and Judge Carter agreed, the legislature does not define extraordinary circumstances, but it does define factors. And now I have seen 5 or 6 cases which Judge Carter cites, all of them were cited in my response. I should probably just disseminate my response to that, because it's so on point. So if such motion is filed, the legislature, while arguing on the floor about extraordinary circumstances, states there shall be aggravating and mitigating circumstances. Aggravating circumstances, only 3. Number 1, the principal was not committing crime alone, and he was the one who was convincing other youth who are reluctant, but he was a leader of a group, or he or she was a leader of a group who convinced the others for the commission of such crimes. Number 1. Number 2, the crime was committed in a specific heinous and cruel manner. And number 3, the youth is not amenable to services. There's a history to show that this youth is not amenable to services. 3 aggravating factors. Under the youth not amenable to services, the legislation goes and further explains that there are number of crimes that have been committed over a period of many days. I'm quoting. Number of crimes committed over a period of many days. What that means, I don't know. And then what they say, those are aggravating factors for the judges to look at while deciding are there any extraordinary circumstances. But the legislature says, we're going to give you a list of mitigating factors. And the list goes on and on and on. Physical challenges, emotional challenges, truancy in school, which now people use all the time as they think it's an aggravating factor. It's, matter of fact, it's mitigating factor. Challenges of a family, no family support. This youth has mental health issues, substance abuse, untreated issues. I mean, it goes on and on. So anything you can use to say this happened to this youth, that's why he or she allegedly committed this crime, you can use as a mitigating factor. And then it says 1 out of 1,000 cases shall be found as case with extraordinary circumstances. 1 out of 1,000. And then I start looking at now what judges decide, and they all now referring to that. So if you see language of aggravating and mitigating circumstances, that's exactly what judges are talking about. Because when I first look, I'm like, wait a minute, what? And then they say, what people usually don't realize and argue is they argue that they can prove the elements of the crime. They don't talk about the principle. They talk, majority of the time, they talk about the crime, as they did about my client. How he was reading it, what kind of marker he used, that the marker was permanent, that this and this and that. And I said, Judge, it's all great, but all they're saying, we have enough evidence to prove every element of a crime. So what's extraordinary about that? Yes, any crime is extraordinary by its nature, but they're saying we have all the elements. Yes.
Has Carter ever found extraordinary circumstances?
Yes.
He has.
One case in particular he did when a youth had 3 or 4 robberies pending at the same time. So it's number of crimes committed over many days. That was the one, I don't remember the name, but it will be here. That was particularly, I know he did. So what we do, what I did in that case, they pulled out that probation report and said, look, he's compliant with every service. They can't say he's not susceptible to services. I said, I gotta do it. I mean, that's what the legislature told me to do. So that would be the last decision that will come out in our favor, but he recognizes that knowledge of aggravating, mitigating circumstances. He does acknowledge in that last decision, he said, I can say that this crime, taken the elements, may be in unusual heinous manner because of the type of the marker and size of the letters, but he says, unfortunately, it's not that unusual anymore. So they couldn't prove he committed a crime alone. So that was not an aggravating factor. He said maybe heinous but not unusual manner. And though he committed those over the period of many days, he was, what I stated, he was never convicted of any of that, Judge. So you can't, and there's a case on that. There's a case out of different county where they say that the kid had 1 JD, 1 youthful offender, and committed a crime. And that was not enough because they said they don't have a conviction. So, but I don't think Judge Carter buys that argument. I think as long as you can say the acts were committed over a period of time. But out of those 3 aggravating, they didn't have majority of them, and then mitigating, I had all of those factors combined with no sort of good sworn statement. That's how we got that guy to family court. Last, when decision is made that this case is going to be removed, we all now happy, right? We still have an argument to be made. Judge Carter has authority to remove case to adjustment by probation. So when we say removal, it's great, but the statute allows us to argue, Judge, it should not be removed to family court. Remove this to adjustment. Adjustment now, December 12th, they changed the statute a little bit. December 12th of 2019, it's 90-day adjustment period. So the case goes to probation for adjustment. They set up conditions, restitution could be paid for that. The order of protection can still last for those 90 days. And if youth is not cooperating, the probation department can file a petition in family court. So the argument shall be, Judge, if he is not doing what he's supposed to do, they can still file. Doesn't preclude them from filing in family court. But try to argue each and every time, we consent to removal, but we don't consent to removal to family court. We would like him to remove to adjustment. Property crimes, he usually does it. Questions? Yes.
Okay. Thank
I
you
know.
for explaining that.
Well,
That was super helpful. So what about removal to probation?
That's adjustment.
Okay, so is it one and the same adjustment? It's the 90-day period?
90-day standard adjustment.
Okay.
Prior to December 12th, I don't know if you need to know that. if complainant wanted the case to be in family court, probation had no jurisdiction, they had to file. But it's in Family Court Act, it's Article 3 of Family Court Act. But if case is removed to adjustment, now probation don't have to, they may listen to the complainant, but they're not obligated to comply with the complainant's requirements for that case to be prosecuted in family court. They can still remove it to adjustment 90 days. If your kid does what they needed to do, case is done, sealed, like never happened. Yes,
So Carter can agree to send it to adjustment even though the objection of
Correct. Absolutely has power to do that. Yes, David.
So just wanted to make sure, I think I heard what you were saying, because this is, the judge kind of smirked at me a little bit when I brought that up. And I said, well, we would prefer that it go to adjustment. And he kind of, smirked, I mean, respectfully I'm saying, because he knew that I knew.
He
case
probably
is
was
over
happy
with.
to hear.
Right, case is over with that. Then there's no reporting anything, no coming back to court, no after
You're
services.
absolutely
nothing.
right. No reviews, no compliance date, no nothing. Case goes to adjustment, and they cannot bring case back to criminal court.
Right, and
No
that's,
way.
and that's what
The
my client
only-
said. He's like, I can do 90 days of probation. I don't want to go through this whole rigmarole.
It's not even probation. It's
Right.
adjustment period where Department of Probation monitors your client leading law-abiding life, maybe paying restitution,
Sure.
maybe attending school, whatever conditions are there. They are not even on probation. It's an adjustment period, what it stands for, adjustment for 90 days to see how your kid is doing. And if he does not comply, if he's MIA, if restitution is not paid, whatever, it is done by probation. They make that determination to bring this case to family court. Now, little caveat, if somebody does JD, if case originates as JD, probation sometimes make that determination and put a case for adjustment. Not every case starts as a petition. Judge Friedman, and I've been so unsuccessful with her, but please try. When Judge Carter removes case to Family Court Act allows us to argue again. Judge, please send this case to adjustment. She has power to do that. I was just not able to convince her that she has that power because I don't think a lot of people are aware that you can actually make that argument twice. Because she said, well, if Judge Carter decided it stays here, it stays here. I'm like, oh, no. And its statute is so clear about it. So please. Any other questions? Well, if case stays in criminal part, then we will hope for YO, right? Just a little reminder on YO. I have a couple of cases that I'm asking Nick Tuxedo to help me on. YO it stays the same, but the case I have, so you know, my client is charged. I think, Joe, you have a co-respondent. It's a robbery case, and my client has a prior JD adjudication, and people would not consent to YO. And judge, and the way the statute is written, if the client, if the youth has a prior JD adjudication of designated felony offenses, and you can look in Family Court Act what those are, he is no longer eligible for a YO unless judge can define mitigating circumstances. So that's the case I have right now, and it's hard. So I think we just have to look at YO. It's 720 criminal procedure law. Just look at the definition, at which youth is eligible, what are mitigating circumstances. There are actually minor ones and not a lot of them. So yes.
So I have a case right now that is similar to the one that you just described, where he was charged with a violent robbery, and then while released under supervision, committed another similar robbery,
Okay.
and is also the primary suspect in the third. Okay, I had the plea worked out with the prosecutor, and it was going to be YO, and everything was good, but now it's So I'm trying to figure out because what I was told and is that if I can figure out how to have both cases before the judge on the same date, and then he takes a plea to them both, that he has to give the YO on both matters.
My understanding, and maybe you should talk to someone else on this, if sentencing happens on the same day,
Okay,
not the plea.
okay, so I need to clarify that.
I think
it's a
for
very
the,
important
Joe,
thing.
maybe you know more about that. If
Sentencing
sentencing
situation.
happens on the same day, it pertains same to the violent felony offenses. For example, if we say that the second violent offense, if sentence happen on the same day, if there are two crimes, I think it's still decided as one. So I would assume same applies to YO, not the plea date, the sentencing date.
So,
That's my understanding,
I think
but
you're correct.
please
Yeah.
check it
So-
out. Kevin,
so-
maybe you
Yeah,
know.
that makes more sense
yeah,
than
it
what
does
we were
make
talking
sense,
about.
yeah,
When it sounded close when you were saying if he takes a plea, but it's not the plea,
it's the sentence.
it's the sentencing.
So, and then the other thing that, that was suggested to me in terms of mitigating factors, that I wasn't even aware we could do this, so I'm so glad I came here today, is to have Tara do a.
That's different, Hope. What are you talking
To have
about?
Tara do.
That's different.
Okay,
So what I was talking about is the first 30 days of the case. Everything what I said so far, except YO, is first 30 days of the case.
Okay.
If we lose everything what I've talked about,
Mhm.
then the case proceeds like any normal felony you ever had in your life, except YO,
Mhm.
that you argue, get consent, or judge commits to that. Then your client takes a plea. Your client takes a plea, and then doesn't matter if judge commits to give you YO or not, the people say PSI, right? Any time that your client faces more than 6 months in jail, criminal defense people correct me, that's my recollection of the statute, anything more than 6 months in jail, judge has to order PSI unless we waive it. If judge says I'm giving conditional discharge, you're gonna waive it. So what we do in every single case, please do that. Pre-sentencing memorandum. Couple of interesting things about that. I always attend PSI with my clients. I always do that. And they still say some incredible stuff, but you ask the judge at the time that the sentencing date is set that you would like to be notified when the probation department is going to interview your client. That's what you do, number one. Number two, you meet with your client hour before, usually an hour before, because they're not gonna remember if you meet with them week before. What I do, if they are in detention center or at the Department of Probation, they say, okay, my interview is 9:30, January 5th. I say, we're meeting at 8:30, family court building opens at 8:30, I'll meet you on the second floor. We sit in that little waiting area, or I go to the detention center and I sit with them for an hour before. And we talk about it. I don't ever tell them what to say, but I'm like, listen, are you remorseful? How do you feel about if you would be like? I try to put them in a kind of stage to say, well, yeah, that was not nice, right? But we have to tell the judge that we're preparing pre-sentencing memorandum, and they have to allow you to do that. It's statutory. The PSI has to be provided upon your request. So what I do, I say, judge, I want to look at PSI. I say 10 days, but as soon as they get it, I always get a phone call from somebody from Part 5 saying, hey, we have your PSI. And you're entitled to that. So you need to know, it's not maybe, it's not, county court will tell you, it's here, go and look at it if you request it. You have to request it. On the record, say, I want to look at the PSI. Now, PSM, I'll answer your question before I forget my thought. Pre-sentencing memorandum, there's no timeline. You can walk in the courtroom for sentencing, give it to the people, and one to the judge. I usually ask Tara to send it night before, and people hate me for that. I had a homicide with a friend of yours. I came with a PSM, pre-sentencing memorandum, on the day of sentencing. It's a homicide. I said, here's your copy. She was like, I can't believe I was not giving this. And I said, well,
That's really
I said,
standard.
read the
Get it on the
statute.
day of
She's like, how about courtesy? I'm like, yeah. But anyway, so we have no statutory provision that we have to give it in advance. Please do if you feel like it, and I think judge should have that in advance. But so you know. I'm just giving tools in your pocket so you know that you are entitled to have it. You're entitled to see PSI before, and there's no time frame when you should give copy of your pre-sentencing memorandum to the people. Oh, David, you had a question.
So how do you toe that line where you're trying to be respectful to everybody in the court, including the court clerk, and at the same time knowing that you're entitled to a copy of that pre-sentence report when you are met with, this is our only copy, we're not giving you a copy, we're not making you a copy, we're not permitting you to make a copy, get it back to us.
So what I do then,
How do you toe that
I'll
line?
tell you what I do. Then I say thank you. I've done it so many times. I've argued with every judge to the point where they hated my guts. So what I do, I'll take it and I take my time. I sit there for an hour, hour and a half, 2 hours, and I read it. And I talk to my client. Youth part does not do that. They will give you PSI, and what I do, I always send it to Tara. Every single case, I never went to sentencing without pre-sentencing memorandum, not once. And every single time, Tara had copy of PSI. Yes.
It depends on who you're in front of, but at times I have, on the record, told the judge I need a copy of it. So I'm not ready to go
Oh,
forward.
absolutely.
On the record, when you say, Judge, I'm not prepared to proceed today because of, they were worried about it, overturning on an appeal because of ineffective assistance of counsel or whatever that is. And you can do it without, you're not saying like, I didn't do what I was supposed to. I received this document today. I need time to review with my client. I'm asking for an adjournment, Your Honor, to get a copy, and to get a copy so I can go over with my client. I've had judges give me a glare, but I've never had anybody say no.
I thought that David was giving an example of when you're told you're not getting a copy,
Oh, okay.
when you're told you're not allowed to remove the copy from the file. And I had that happen. But in most cases, I never had a problem when you requested. That's where I think the biggest problem is when you're finishing a plea and everything is happening at the same time and everybody's nervous. You have to kind of stop yourself and say, oh my God, I have to ask for it. Then I would put on the record at the time of the plea, Judge, I would like to be notified of the interview. Here's my information, they have it. And I would like to have a PSI in advance of sentencing. I ask for 10 days. I don't know why I came up with that number, but I say, can I have the PSI 10 days before? And they're like, oh, we're not sure we're gonna give you 10 days, but we'll give you when we get it. That's usually the standard answer. And then I had different judges doing differently. Some clerks would email it to me.
Right.
Some clerks would call me and say, hey, Lana, we have your PSI. Some I would get through the normal chains. I'm there. They're like, oh, we have a PSI in different case. But once in the blue moon, I would have some judge would tell me, you're not allowed to remove it. We're not photocopying it. Then I would say, well, Your Honor, I would quietly sit in a room and I literally would take my time. And if the judge says, are you ready? I'll say, Judge, I need more time. I didn't have a time to read it throughout. And I want to make sure everything in the PSI is correct. But it almost never happens. So yes, Kevin, you're absolutely right. But I thought the situation you were asking about where you're not allowed to do that.
That might have misunderstood.
No, I mean, what Kevin said is helpful, but I'm just saying, I have encountered that problem, and it's usually with the court clerk, and as we all know,
I know the specific judge that has that problem, but I always sit in a corner and he takes the entire calendar, and now he knows. He would say, well, Ms. Stopchik, how about, did you have a sufficient time to review the document? So we got to that level now.
I think it's different philosophies of the courts too. Some think right of privacy, they don't
Right.
want it out there, there's personal information of your client. But then Judge Case emails it. Judge Mahalski's clerk emails
Like I said,
it.
we're not gonna name names here, but a lot of judges will just email it to you, and statute does allow us to have access to it. So it's very clear. And the last thing on sentencing in the youth bar or criminal court, if you have the PSM, and especially on, when I say PSM, pre-sentencing memorandum, those are ours. especially in sex-related offenses. I never go to sentencing without Dr. Cervantes' report or any other doctor who would say there's no mental health abnormalities for the potential Article 10 proceeding. I specifically asked, and that's what Dr. Cervantes told me, never finish the sentencing without specifically asking that her report and the pre-sentencing memorandum report being attached to the order that goes to Department of Corrections. So you have to make that request, the PSI, pre-sentencing memorandum, and whatever expert, it's, like I said, especially in PL 130, that it has to be attached to the order of disposition. Wow, we did it. Anything else? Any suggestions? Anybody else had any different experiences? Any other suggestions on what we can do?
just like do this periodically though, like? Sure. I think it's really important.
Well,
I think really
absolutely.
good.
I just wanna go in here, come in a little commercial. Because these are criminal cases, all of the resources of Correll Herring are available. So Tara Evans to do your sentencing, you can call Nick Tuxedo to help you write your motions or to talk law with, call Judge Franzak to discuss things with. They're always available, they'll go over the cases with you, and unfortunately in family court, at least until we are funded differently, we can't use those resources. But we can use those resources in these cases because these are just plain old criminal cases. And so really, please take advantage of it. They have writers that work on that side. We have writers now that work on the family court side. Please take advantage of the stuff that we have because we have more than we ever had before.
It's amazing.
It is amazing.
Let me tell you, can I share my experience? I was so excited. I had a gun suppression issue that went from Judge Carter's court, was transferred to JD part, Judge Friedman. And I look at the case, and to me, it was questioned on the suppression hearing. And I'm like, oh my God, how do I do that in family court, right? Having a suppression hearing in family court. So I asked for it. And to my surprise, judge gives me suppression hearing. So now I'm all excited, and though the time frame in JD, right, different. So we have like 5 days to prepare for it. So now I'm panicking, and I reach out to Nick Tuxedo, and I said, here's my issue. So I tell him what I think the suppression issue is. He responds to me literally within, 25 seconds. He's like, well, there's a case on your issue, and that's what you need to ask, and this is the issue you have to preserve, and this is a case law on that. I'm telling, it was within minutes.
Yeah.
So I go there.
The guy's amazing.
I give the copy of the case to Judge Friedman. I read from the case as I am cross-examining an officer, and the officer is just giving me, like, I smile as I did it, and gun gets suppressed. I called Nick. He has 2 cases for me right now in Youth Park. Now I'm like, Nick, please, and he immediate. I mean, the responses I get, he writes my motions completely. I bring him a case. I drop the case on his desk. I pick up the complete motion.
Wow.
That's wonderful. I know, it's never been this good.
It
It's never
feels like
been
you're a lawyer once in a while, you know? You have all these motions with case law attached, memorandums of law. They will little email what issues you have to, like what things you have to preserve. It's absolutely amazing what we can do now.
Yeah, Lana, making that terrorist threat a week, 10 days ago, I was in front of Judge Carter, and he was gonna put a cash bail. The Judge Ray had set the bail, he's out, but he wanted to
You
put
know that they just changed that law, right? Specifically on a terroristic threat subsection.
490.20.
Nick, I go, Judge, I think it's excluded, it's accepted. And he said, no, it's a qualifying offense. I texted Nick, as we're on the record,
Yep,
he sent me the law,
Yep.
Judge released.
yes.
Actually, you put Russ on.
That's
Right.
something else I wanted to bring up. Judge Ray's been releasing people, at least the few that I've had, a couple, and the very next day we appear in front of Judge Carter, and he modifies the bail to a Russ. And my argument is, what has changed since 8 o'clock last night, Judge?
correct, and you should be having those arguments, but we had both ways, the arguments, when Judge Ray sets $50,000 on being nonviolent felony. So I had both arguments, as we always do, depends on what works. And sometimes I would say, well, Your Honor, Judge Ray, and sorry, we said that name. But usually that's the judge who we have some issues with. But one argument I had, she did not set a percentage, and now it requires, if you set the cash bail, it has to be percentage assigned to A, C, F, E, whatever. The other time she said 2 forms of bail. Now what I see she does, she puts A through F, like so there's no question. If you have any questions about that, I can tell you what I know, not a lot, but I know something about it. But what I'm saying is, then I would say it's changing circumstances because it's not being complied with the statute. I have said the changes in circumstances because parents were not present and now they gave us more information. I have said the changes in circumstances, now we have something else. Or if it's release, then I would say there's no change in circumstances. Then people argue that they are. So the argument, the theory is correct.
Yeah, so we're supposed to ensure that he's coming back, right?
Well, we have those forms, right? There are a number of things that now legislature tells us to look at. I have them. There are a couple of factors.
But
The prior non-appearances, the safety for the community,
None of that is looked at.
financial hardship
And
of the
certain
family. Oh,
crimes like
here it is.
domestic violence crimes, yes it is. It
Hold
still
on.
is.
The assigned counsel supplied us with this as well, which is like beautiful. And I saw Judge Carter holding them, so he reads from them too. Okay, bail factors. So listed factors CPL 51030, principal's activities and history. If the principal is a defendant, the charge is faced. The principal's criminal conviction record, that's important, right? Because we have YOs, AOs, JDs, those are not criminal convictions. JD or youthful offender record, the principal's individual financial circumstances as they relate to the ability to post monetary bail. For any family offense, whether an order of protection was violated and or whether one is in place. For any family offense, whether the principal has a history of using or possessing firearms. If the bail sought is pending appeal, the merit or lack of merit of the appeal. A determination that appeal is without merit alone justifies but does not require a denial of the application. Any other information about the principal that bears on the likelihood of further attendance. But what we have to say that the factors that all of them, it says, must impose the least restrictive kind and degree of control and restriction. So that's sort of the intent, and then those are the factors.
So if he gets out from being arraigned by the accessible magistrate,
and he's in court the next day or 2 days later.
It shouldn't be more restrictive
that was
unless,
sufficient then. Whatever was imposed was sufficient.
Because he's in court.
I would argue that not only has not been a change in the circumstances, but I think when we were here on the bail CLE,
Yeah, I didn't say.
what we've been told, if the more restrictions judge is imposing, he or she cannot do that without a hearing. That's my understanding. I did not have come across of that issue, that they have to have a hearing to impose more restrictions, and it cannot be an oral argument. It has to be a hearing with people testifying.
I've had the last
I think that's correct.
with Judge Carter.
Doing a Russ release after they've been out. He's added Russ.
Once again, I had some issues where I think, oh God, I should appeal that, but
Yeah.
until, when the case is resolved, it's sort of a moot issue, and yes, but we can come to higher court on your issue, bail issue, go to county court and see what they decide.
Thank you very much.
All right.
Yes, thank you.
You press the button.
Thank you.
Thank you. now. I give you all Carter's cases
Okay.
and then.
I'm gonna take these cases and have them copied and send them out to everybody, so you all have them.
But guys, if you have a question about significant injury, weapon, extraordinary circumstances, what I am doing in my own computer, and I am technologically disabled, but if I know how to share it, I start creating like 722 or retention hearing, and then I will be significant injury found, not found. And I just do all the lower cases, but it's easier for me to just go there, open up my file, and email them to you on the specific issue that you want regarding those, like I said, the retention hearings and the extraordinary circumstances.
Lana is also one of the mentors that is working with the program, so if you have any questions.
Yeah, I call my people manatees.
So if you could please sign out, and also I need to have the, quiz evaluation form. That would be great. Thank you all for coming, I appreciate it.
Every time it's
So this should be 1.5 hours of something practice, probably something like that. Thank you very much for coming.
Thank you.
Thanks for having us.
Thanks for doing this.
It's
I feel like we should do it on
I love this shit, I'm telling you.
I mean, I just like attach myself to Lana whenever I find her, whenever I see her.
It's a thought too, I mean, once a month, a side council does a criminal law.
Yeah, I'll take it.
Yeah, they do.
And it'd be nice to, especially since there's this adolescent offender, we have our own meeting,
Right,
or join the one that you guys are holding once a month anyways.
I think it's a good idea for this panel to meet because you're really
Yeah.
different from everybody else.
And everything is new law right now.
Right,
Everything that's
We can
happening,
litigate everything. Weapons, significant injury, extraordinary
Sex
circumstances,
offenses.
sex offenses, right, we can litigate a hell out of it.
I mean, I know,
And just talk about our different experiences.
Right.
What-
Thank you
what's
very
out
much.
there,
Thanks, David.
What's flying and not flying with,
Garcia.
Yes, yes, I'll be back.
with Judge Carter. I gotta go to a reading now.
I had a guy come in, his original case stayed in front of Carter, he'd stabbed his girlfriend in the knee with a butcher knife while she was holding the baby.
oh, Jesus.
And the knife handle broke off. I shouldn't say probably, it might have saved her because he pulled it out. I mean, right here, big butcher
Wow.
knife. Could have spurted all over the place, kept it in. She needed surgery, but then she was fine.
Oh my God.
I think he got a 6-5 split. I know he was definitely on the probation. I think he got the 6-5 split because Carter kept him in until sentencing. And he had to do another 25 days or something. And he was okay with that. He's back.
It's good, it's a good outcome.
That's a really good idea.
It's an excellent
Sentencing.
outcome.
Thank you. Sentencing in May of last year. He's back.
He still is an AO, he hasn't,
And he got
Still
one.
not 18?
He got one AO on it, by the way. They charged him with robbery for forcibly stealing some kid's bike.
Yeah.
But
it's just still misunderstood.
Yes.
We haven't reached them yet.
Yes.
So, but the DA says that the first appearance, it's removal of family court, not even an argument. But we have the appearance in front of Carter, man, Carter lit into him, like was shaking, like I gave you a chance and you're spitting in my, he didn't say this, but I mean, that's what he was. He's like, you made a promise to me. And when I make a promise, my word means something. I promise you I was gonna do something.
Seems
And
like
I
I
did it.
heard it from Carter at least 30
And
times.
you know what, I mean, the kid hasn't heard it 30 times,
Right,
and that's fine.
right. No,
Even if Carter doesn't mean it, and he does mean
he
it,
does.
but even if he didn't mean it, the kid hears it. My client left that courtroom shaking. And this was the interesting thing.
Until he steals another bike, right?
Right. I'll tell you about the bike in a second, because I'm thinking it's going nowhere until I find out, about the victim. Carter says, or the DA tells me that probation isn't gonna bother violating him for this new arrest, because he's doing, quote, moderately well on probation. That's the standard to not be violated, doing moderately well.
Moderately well.
Because they know what's the outcome. They
Carter,
violate him, they can't put him in, they still have to, it's like,
Carter says to the kid, and you know, probation came up, and they asked me, should we file a violation? You know, he never answered what the question was, and he said, so I'm telling you, do not come back in here. So he made it sound like he gave him a chance. He never said, I told him to violate you, or I told him not to violate you, just see what happens. But then the DA's like, this is stupid, because you're on probation. Are you okay?
take my quote.
Excuse me.
It goes over to Friedman, and Amy McCabe is like, what am I doing? It's a JD, he's already on probation, we're not even gonna do JDST release or anything like that.
Adjustment.
Adjust.
They're not gonna do adjustment. ACT, comply with your probation you're already doing. Now, the victim, my client's, might be 17 now. He had just turned 16 when this happened, I think.
Okay.
You okay?
Are you sure?
I'm fine. I'll be all right.
Like, the victim,
Just look down the
11-year-old,
wrong way, right?
11-year-old autistic boy, I'm thinking, so like tears at the heartstrings, right, but bad witness, won't be able to
Well, we're on
identify.
the spectrum.
No, we're talking Rain Man. The kid is Rain Man, he describes every article of his clothing, the color of his shoelaces, what street he went down, and what time it was.
Almost as good as being on videotape.
Exactly, so, I mean, they're still gonna have a hard time qualifying the kid to, testify. But-
Did you have brownie? I'm sorry, I'm interrupting.
Demarion, I was there today for a
I
PSI.
I wanna know what.
Who do you have? George
Small-
Swag?
Mertez Smalls.
Smalls.
And we're trying to figure out, cause I apologize, I
You're
interrupted
fine. I
you.
was
I just
kinda
wanna
done.
know something about this. Because people would not consider YO claiming that there are no mitigating circumstances because he allegedly, my guy was holding a gun. I've reviewed every single piece, including your client's.
He alleges
Interview.
that the pistol whipping where there was a broken orbital
Yes,
was performed by Mark Smalls.
by my client. It's your client. When does he say it? I,
In the interview,
but it's like hour, 50 minutes and I maybe.
15 minutes.
So there's a second interview, right?
No,
Because
it's
the
that.
one they
Told
gave me,
the
it's
authorities.
hour and,
15 minutes.
yes. Is that what he said? Cause I thought I watched it all, but I did not see him say
Let
it.
me look in my file. What,
Can you please tell me,
Tell
cause
me.
I'm telling Cart, like, who decided, where do you see that he is not a minor participant? And he's like, well, it's been alleged your guy was with the gun, and I'm like, I can't find it anywhere.
it might have been during the reading or during extraordinary circumstances.
So I need to order, can you shoot me all the dates so I
Yeah,
order all the
yeah.
transcripts? Cause I can't,
If I
cause
forget, send me a text.
everybody's convinced that my guy was with the gun and I've
that's-
spent 4 hours
Yeah.
looking at the.
That's what I brought up earlier. It's not like criminal cases. It seems like we're throwing anything out there, and the DA's throwing that out there. You know what she tried to say, that hour and 15-minute confession that was recorded in an interrogation was a sworn statement. I go,
How
how's it a sworn
so?
statement? It's out of court,
Right.
you're saying it's the truth. You didn't memorialize it,
It's just the
you didn't-
recording
No,
itself.
all
It's
they
video.
I love how
The
they.
video
Yeah.
itself.
Yeah, the video.
I don't even know where on the video, was it on the video that he said you have a right to remain silent?
What he
Was that at the
says,
beginning?
because I was trying to look at it, he walks in, your client's sitting here, his mama's sitting here. He said, well, before we start, we gotta sign this piece of paper. And they're looking at it, he said, well, you have a right
Was
to.
that the Miranda
Yeah,
warning
he
sign?
said, you have a right to remain silent, you understand that, right? And they're signing, I'm like, they don't understand it, like, anything
How
you say
stupid
will
can
be.
that cop be too? He knows it's on video. You gotta be extra careful.
And that's where you admitted to all the robberies and burglaries.
Right, right,
They were
but,
trying to say my guy was a leader. And that was the extraordinary circumstances. They used the robbery with Smalls, where it was a broken orbital,
yeah,
to say, you gotta keep this robbery of the purse that was caught on videotape
my client
here
is
in
not
this
part of
court.
it,
No,
My
he's not with
client
the
only
purse, right?
part of the broken orbital.
Yeah.
Yeah, and now they wouldn't, I can't get YO because they're saying the judge cannot.
From a hearsay comment,
Yeah, but how do you do the mitigating circumstances? That's what I am.
there's more people involved in the crime, that's enough mitigation right there.
So, well, I gave it to Nick.
So he's
Tessino.
denying the YO?
He can't, he said, I
He's
wanna
denying YO.
give it, he said, I wanna give it to you, but I can't find mitigating circumstances. I said, well, I'll find them for you, and now I'm digging, trying to find what the hell.
Well,
But I gave it to Nick, so I'm
Here-
not
here
worried.
he
He's
is.
objecting to the YO.
we were there today, and
Absolutely,
we
they,
needed.
they're horrible, they stopped giving me, cause we moved so much, I didn't go. I got
Yeah, it was already thirty.
But it's starting to get changed.
You should get
The
used to it.
tide is
You should
changing
feel it
though,
occasionally.
guys, the tide is
Right.
changing because
It is.
the very first AO I had, Barnese, Bob Goldstein had him on 3 robberies. He received YO in front of Barnese, got a split, got violated. Barnese gave him a 1 to 3. He gets out on parole, so he's already seen state penitentiary.
Right.
Gets out on parole.
How you could have given 1 to 3 in radio, it's 1 and the 3rd minimum, am I missing something?
No, 1 1/3 max.
Oh, okay.
1 to 3, 1 1/3 max.
Oh, I thought.
So he's on parole, okay?
Yeah.
And he ends up being a JD now. He's on parole, okay?
You went to state, and it's still your.
Yeah, one of the very first cases.
So,
Because
right,
it said 1 in 1,000
yeah,
stays here. 1 in 1,000 should go to family court. But he already had 3 burglaries. Bob Goldstein, I guess,
I had a,
Pled to
I had
one.
a code. I had a
on
code.
that case, I can't remember the guy's name either. My guy's name. But Barnese gives him a 1 to 3. Now he's on parole. He gets out.
July
He's
before.
still, now he's 16, okay?
I had a code on that.
He's got the ankle bracelet while he's on parole, and he kept letting the battery go dead.
Oh, gee.
Now they can't find him. Parole officer spots him on the streets, goes out looking for him, spots him on the street, chases him down. He's got a loaded firearm in his pocket.
Oh, jeez.
All right? What do you think? It's staying in the court. No, the judge sent it no, and why he's in detention? He beats the shit out of
You know what we
detention
did
worker.
on that case? What we did, we pled to a lesser included, and by statute, it was removed to family court. That's what
You
we
had a
did.
call on it?
Yes. So.
Well, now they ended up
Right.
doing a state bid.
Right, but what we did, because if it's under JO, because they were all under 16, it was JO cases. They just decided to move them later to youth park. But as JO.
Not my guy though.
I'm telling what I did on my guy, now I remember. What we did, we planned it down to, that would disqualify him from JO, and it went to JD for disposition. That's what I did with my guy on that case.
Yeah.
But yours was like.
Mine, he went and did a 1 to 3, he's on parole.
I felt so good on
Gets
that.
caught with the gun on him. They did in extraordinary circumstances. Meredith put that all out there, and that's what's crazy with this. You throw everything out there.
Right.
The motion was super friggin' thick,
Right.
saying everything. Even while he's in detention, he's beating the shit out of a worker, and
DP,
the guy was out. The guy was out of work because he got the shit kicked out of him by my client.
And he still
The
goes to jail
decision
for
is,
it.
it's going to juvenile delinquency, family court.
yeah,
And then you got,
this is the
so,
case, right?
so we admitted to it, is this it? Do we know what the guy's name is?
DP?
Yeah, I can't remember.
You got written decisions?
I got
Are
all
two written
partners.
decisions?
Yeah, a bunch of them, yeah.
Like,
Oh,
So
yeah.
this is
Yeah.
every single one he wrote so far.
Yeah, and this, you had the code then on this.
Yeah, but I,
So,
yeah, so that would be DP, I don't know what your guy's name is, but that's his initials. And another one, you had DB. That's,
is that Demarion Brown?
yes, that's Brownie.
Yeah, they used a significant injury of the
Yeah.
one robbery.
So two
keep
on,
going.
Carter issued 2 on your cases, so
Yeah.
I believe that one is DP.
DP.
I think one of those is mine.
And I got 2 that are being scheduled, but they're gonna bring
But he
motions
didn't
for
have
extraordinary circumstances.
publish it, you know.
Hey, you know what I wanna ask you, what's your thoughts on the sex offenses? Is it any sex offense?
I had one rape and people on consent, we removed it to family court, and I just got another one.
but we are, well, we didn't have, I conceded the 6-day
What about
hearing
forcible touching?
by forcible compulsion, and I believe my.
Well, it's forcible compulsion. I got a guy who's touching breasts.
I have rape in the first by
Right.
forcible compulsion,
Yeah.
it's a JO.
But isn't it any sex crime? Keep it in YO.
I haven't had a chance.
Keep it
My
in youth
sec-
court.
Like I
Yeah,
said,
right, right.
the first one was removed,
Yeah.
this one we're keeping because
Why did-
people wouldn't consent and,
Why was it, oh, it was by consent that it was removed?
the first one was removed by consent. Second one, now it stays because I lost the
Yeah.
retention here.
I got another one coming up where he videotaped
But I'm gonna take it to church.
a 12-year-old being having, by consent, sexual intercourse with a 16-year-old boy. My guy was in the driveway videotaping through the basement window.
I'm taking mine to jury trial because the
Wow.
girl did not talk about it for 2.5 years when her mother found out.
2.5 years transpired? Wow. There's some strange cases.
Yeah, I don't know why they're prosecuting it. They're both met at one of the mental health facilities.
Oh, Jesus.
He is still, and they charge him under the subsection where he's still like 15 or 16, but it will not be an affirmative defense because they kick the subsection that would make him ineligible for that affirmative defense that he's less than 18.
I'm not aware of this subsection.
Yeah, they're in the same statute with one, so they picked unable to consent for mental health issues and then by forcible compulsion, so. I don't know what I'm gonna do with it, but
How old is the girl?
same age as my client, 14, 15 at the time it happened.
They're tough. They're really tough.
This case is gonna be.
I pled one out and the kid,
That one they removed to, consent right on the ACD.
yeah,
They could not, well, what happened, so you know, they had a 6-year-old victim. Six.
6-0. Oh, 6. Oh,
The little girl.
Yeah.
My
They
client
can't proceed
was
forward.
her cousin, and they did 2 MDIs at her, but because they did not prosecute the case for over a year, they were investigating. CAC do not keep their interviews past 220 days.
Wow, really?
And like I said, if we just be quiet about it, because, so by the time we had the AO part, we moved it to Freeman's part, I scheduled it for trial.
Evidence is gone.
Amy came to legal is gone, we have to put the 6-year-old on the stand. I'm like, great, why don't you do that? So they have to do an ACD.
They're gonna put a 6-year-old on the side. What's the minimum wage?
So it's 7?
What's the minimum
7
wage?
for qualifying
I
somebody?
think it's 8.
And they still have to, you still have to qualify.
Right, but
Yeah.
I think that the girl, because when it happened, they waited for a year, so I think she was coming closer to the 8 at the time of the trial, but what I'm saying.
ACD.
ACD, I would not take anything.
Wow. Very good.
Yeah, but that's how I
Now
found
he's have
out.
to do another. How old's your guy?
I think he's 16, so I have to look, I don't remember. But,
He'll be back.
Yes, he
He was
was.
a pedophile.
Yes, he
Yeah.
was.
Wow.
Yeah, if you're, he
but it was, he
didn't just lose the ability to control himself,
Cousins.
12 or
They're
13-year-old, 6-year-old.
It's not like they were just, you know,
You're
show me
already
what you
broken.
got, I'll show you what I got.
Right.
Yeah, you're already broken if you're doing that.
Yeah.
and the girl showed it and described it allegedly, but by the time where I filed for discovery, it's not in me. It's like, oh,
Yeah.
I don't know how to
I'm
explain
not
this.
too impressed with the CAC in Buffalo.
No.
You know,
Absolutely
the
not.
trials, the AFC on a case, the interview didn't impress me.
I go
And
through
we
every
had,
time.
we had
I-
Heffler testify that the guy, he basically said, I leave my grandkids with this guy. He's not a pedophile. And
Yeah.
Lovallo
I went
dismissed.
a number of times there and observed my own clients. I can do a better job.
Yeah.
I'm not saying I'm
Is
good,
run
but
by
I can
best self?
do a better job.
Yeah.
CAC is it run by Best Self?
I don't know.
No,
No, Catholic Charities, no?
I don't know who runs it,
Somebody-
Child Advocacy Center.
Right, somebody said that, I had an argument with a counselor at Endeavor that they were closing out their case for counseling for my 4-year-old client because he's nonverbal. But Endeavor said, we're
I
closing
thought it
him up,
was like CAT's a separate organization.
and he's going, and we sent him to CAC. I said, but CAC isn't counseling, CAC is one or two investigators for a
They do
crime.
have a counseling, on upstairs. But I don't know if they set counseling for ones that they
Maybe
just
there's
tried.
Maybe there's an organization or a division of Bethel that uses that.
There are two buildings with CSC. One has a pediatrics unit where they do MDIs, and those are Kaleida Health.
Okay,
And then you go, actually the pediatric unit on the back. Up front, the building, it says Child Advocacy Center, and I think it says Catholic Charities. They have to look at the
yeah,
more of the sign, but
yeah.
I've been there a
I
number
give
of
it a
times,
courage.
and I'm telling you, I'm not impressed at all.
Very nice job, thank you.
Thank you.
No, I appreciate
Thanks for
it.
coming.
Bye-bye.
No, I want to do more of stuff, I'm just busy. Everybody's in the same boat, it's not just me, you know, but I'm doing, right now, I've got twice as much AFC work as I did last year, so.
Yeah, Tom Duschel retired, so they all.
Well, I was picking up enough on my own, and I've got a couple of Vanias. Hopefully I'll start to get some of Duschel's, and I've been doing it long enough now.
Yesterday, I was kind of hiding, there were like, cause Tom was, I'm not taking this, I'm not taking that, and they came out on the floor, I was moving as fast as I could, so I saw there, I'm like, here, they're looking for you. It's, I can't even do it anymore, it's
Well, it's-
like,
And if anybody complains, about me, it's just because I'm busy. I haven't put my name on the AO or the AOD list in about 9 months. I'm there all the time anyway, you still get cases walking up and down the hall, I almost always say yes.
but it's good, right? It's a good problem to have.
Yeah.
Thank you very much.
Yeah, but you gotta do something to get in your favor. I absolutely love it, cause it's,
I've done about 5 or 6, but a couple stayed in and they were easy pleas. The other one I had, do you remember last year when those kids stole the car and there was a baby in the back and they took it up?
Yeah.
I got one of those kids. But so interestingly enough though, they have, right, and my guy goes, there's a baby in back, I don't want anything to do with this. He was driving, he parks the car on the side of the road, gets out and walks away.
and he's the only one who knows how to drive, right?
Right, he's 15 and he goes to the Stanley Falk School, so he's got some issues, right? The guy who was in the car with him was 17 or 18, could be prosecuted as an adult at the time. That was before the 17-year-olds. So he gets in the car, takes it over to his girlfriend's house, parks in the alley, goes, I gotta show you something. So they take the baby out of that vehicle, ditch the vehicle, they put the baby in her vehicle and drive, and they're in Buffalo. They drive it up to the hospital in Niagara Falls and say, we found this baby. So that's the only part of the story that made the news. We found the baby abandoned on the side of the road.
Oh, Lord.
How stupid.
So there's, but they're looking, the hour and a half or so it took, there was some surveillance video from a 7-Eleven. And so they had, on the news, they had some mugshot surveillance stuff.
Who left the baby in the car though? The woman went to 7-Eleven, left the baby in the car?
Yeah.
She stopped at a liquor store. She ran to the liquor store to get her pint of whatever she needed. She comes back and the car's gone. Well, these kids were standing at the 7-Eleven when they realized, oh, she's left the car running, let's go grab it. So they walk across. They've got their photos on the news for, all the news stations are cooperating with the police. No. Some guy's watching the news, he calls up 911, he goes, those are the 2 knuckleheads that robbed me at gunpoint last night. He could not give a description of them other than 2 black youths. So I've got them, you almost got them, because I was there, I was there the same day as you, and I think you said you were busy, so Kevin, do you wanna take this one? And not.
Probably, like I said,
Well,
you
right,
know,
just-
and now I'm,
You've been doing so much, and this was last year, but you've been doing so much of
Yeah.
it for so long. And so,
so I get lucky.
yeah, so the robbery at gunpoint stays in Carter's part. The taking the car, they didn't charge him with kidnapping or anything like that. It was clear, they had no idea the baby was in the backseat of the car. And also all you have is UUMP.
Oh, that's so funny.
Or grand larceny, or whatever, and so that one went over to, Friedman. So I had him in both, and he got probation on the other one, and it's not even staying here because he was already on JP for a stolen car in Niagara County.
Some guys are just not cut out for a life of
So
crime.
I said that to him, he had one that he was already sentenced to probation up in Niagara County, one he was pending sentencing, and then this one here, it's all this guy he was hanging out with. My client was so impressionable, and I tried hammering that. I said, he never did anything like this before.
Like this, right?
But now he has.
No crimes at all. He meets Joe Blow, he steals a car, they get caught. Him still hang out with Joe Blow, they steal another car, they got caught. I said he needs to stop hanging out with Joe Blow. Carson, he needs to stop stealing cars.
Oh my goodness.
So, I don't know. It's good to be busy.
It's good to be busy.
Speaking of busy, how many hours a week is this thing you're looking for? Do you know yet, or is it in development? Is it steady?
It's $20,000 a year. I don't know how many hours a week it's gonna take, but it's by stipend. So it's, we try to get one CLE a month.
Yeah.
What you need to do is solicit people to speak, and make the arrangements and go through all that stuff. So I don't think it's gonna be real heavy lifting. I mean, I know I do it now and it's not.
All topics of family court?
Right.
Yeah. I'll send you my resume. We'll
Okay.
talk about it and game plan it a little bit.
Alright, thanks.
There's some resources for me to go off of here and then start from scratch, right? Well, it's gonna be in conjunction with you
Right.
a little bit.
Yeah.
I mean, I've talked before and it's been a long time, but, and I've been doing this long enough, I know a lot of people. But I think I could pull it together, but we'll see.
Alright, send me a resume.
I gotta go. I was making sure he's not gonna pass out here. You okay?
Yeah, okay,
Alright.
thanks. Thanks for doing that, that was great.
I love to talk about what I know, you know what I'm saying?
Yeah.
When I'm asked to talk about disproportionate minority representation, I don't know what to say, all of my clients, 90% of my clients are black, I mean, how do you hide that fact?
Right.
Yes, I caught one who was clearly out of his mind, but that one in 1,000 I ever represented. And I can't talk about something that I don't know what to say, this, I like it, I research it, I talk about it, I believe this,
Yeah.
Did either of you watch Dershowitz yesterday?
No.
See, oh, you gotta find the clip of it and listen to him. I am a mental dwarf compared to that.
Yeah, well, pretty much everybody is.
Right, I mean,
Like Tim Franzak.
yeah.
I mean, you're just not as smart as him. I'm not as smart
But
as him.
just the constitutional arguments he was making against the impeachment, he's against impeachment, but he made a point of saying, I'm not political, I love the Constitution, and I'm advocating for the Constitution. And he said, I've done it, and gotten the bad media press for the unsavory characters in the past, and apparently that's happening again, because some of the Dems attacked him and said,
She's
oh,
a damn son.
I know, I'm talking about, I know you, but this is just kind of factual stuff. That Trump's team couldn't even find a constitutional lawyer, so they had to go get a criminal lawyer to make the constitutional arguments. who are these idiots that say Dershowitz is not a constitutional lawyer?
Right.
A lot of his work is done in the realm of criminal law, but criminal law at its core is constitutional law too.
You
And he
can't
teaches a
separate.
common law class, and, I mean, I haven't always liked the guy, I loved listening to him, I was mesmerized listening to his story. He went on for an hour and 15 minutes, I think he took a drink of water twice. He looked at his, and like I said, and his notes were this thick, his typed up stuff, and he was looking at it, but he was finding his place as he was going along. He only read
See,
a
I
few
lost my
times.
place. I went half of the slides and then.
Yeah, but you didn't.
But you didn't need them,
Right.
everything you were doing, you knew what you were talking about, like you said, and you went off memory, so.
Cause I believe this, if I could just raise the age, I would do it, cause in my mind, I know so many more issues we can create, like, there's so many more we can do.
So next month I'd like to do a CLE on more, just kidding, on raising, more raise the age stuff.
But, you know, that's the only stuff we know, and like you say, if he lives, if it's his passion, then it's powerful.
And I mean, it was kind of props that he pulled in from, went to Harvard Library, but they were talking about the
Put
Johnson.
me in the Harvard Library. I will not know where to find the bathroom, not only find the stuff that would be pertinent. You know what I'm saying?
Yeah, but he didn't go look for it, he sent one of 30 students that are tailing around behind him and said, go find me this book. He had the edition of Blackstone's treatise on constitutional law or criminal law, I forget which it was. At the time, he had the edition and an actual print version from when Johnson was impeached because they quoted Blackstone.
Really?
So he had the book, he brought it into the Senate from 1840s? When was, I don't know, whenever Johnson was impeached.
Wow.
1830s?
Long time ago.
He brought it in, had a pink sticky note on it, so he opened up to the page to read from.
Some people are so smart, it's
That's what Franzine's like.
Yes.
He's a genius. I mean, you just start out, you know,
Mm-hmm.
I am not as smart as him. I know that without question.
You could see it when he was on the bench, but his role was more limited. When he was doing the CLEs and stuff for Assigned Council, when we started those several years ago, and we went out to the UBs,
Right.
you really sensed it then. Or when you did his mock trial competitions and stuff. Just, because he wrote most of those,
Yeah, he writes the problems.
and he says it takes a lot of work and he tweaks it, but I'm like convinced. He sits down with a glass of bourbon and he's like,
He just
well,
writes
can
it.
we come up here? And he's got it knocked out in one night.
Yeah, I'll bet.
I got my swastika decision.
Oh, cool. You can send me
email, I'm gonna, so you have all plus this one.
I will send them all out to everybody.
This was exciting. It makes me want to throw my name back on the panel and do more of this stuff.
I wish you would.
Yeah, please.
Just the list of orders, you know, that or motions and orders that judges are waiting for me to turn in is so long, and
Mine too, mine like 3 pages, just.
I've been like really manic the last week and a half. Like I was supposed to do all this stuff over Christmas break and didn't do any of it. I didn't get further behind. No, it's all of us. I didn't get further behind because I went into the office for a few hours every day and made sure I was caught up on things. But all that list of stuff, so now I'm like, all right, we're past the holidays, I'm not hunting in the fall, it's no Christmases, there's no birthdays, whatever, evenings, weekends.
When is the next cruise? Let me ask you that.
End of February. So I got to get all the orders done and
You
turn
know,
in.
you know why I'm asking, because I'm going to Disney on the 11th, and I'm thinking,
I don't freaking have enough time to cut up what I didn't do during my Christmas break.
Well, we've got a couple holidays, the 12th of February is a holiday, I think.
Yeah, that's
Yeah.
when I'm going to Disney.
Oh, yeah. And I thought we're going the last week in February, like the 24th or something like that. I didn't think that was a break, but in Boston yesterday, Judge Vaco was trying to schedule stuff and everybody was like, no, I'm not gonna be here on the 24th.
Because every state has a different time for winter break. They tie it to different things.
Yeah. But around here, I thought it was February and sometime in March, early February and sometime in March, right?
The week of the 13th or the 14th is the school break.
Oh, I got a school calendar, they still mail them to everybody in
But
town,
every different schools have different
Yeah.
breaks.
but nobody was gonna be around.
Anyways, Russian accent.
understand everything what I
Yes, I
said.
understood everything you said.
I was trying.
You made lots of sense.
Although you did call Nick, tuxedo instead of tuxedo a few times.
Oh, see, that's it.
Mhm.
I thought it was tuxedo.
It's tuxedo, you said tuxedo,
I said a couple, because that's what I thought, thank you for correcting me. I would be upset if somebody called me, oh no, they call me different names anyway, so, but anyways, yeah, that's, thank you.
yeah, but usually it's Russian spy or something like that. And this
So,
thing is
tuxedo?
tuxedo.
He's great.
He's a smart one too.
He's, oh my God,
He's
he's
learned many fronts.
He's a smart one too.
I'm telling you, when he sends his shit back to me, I feel like I know what I'm doing, I'm telling you.
And you just, and anything, pretty much everything I've asked him,
Yes.
he has an answer to like that.
Any issue.
And throw me in a courtroom, and give me 5 minutes to look at a file, throw me in a courtroom.
Yeah.
You know, but to write the motions and stuff, I hate it.
I do too. I hate it.
And
I love
remember, I had a case, it was somewhat of a serious case, but we had, it was Amber, so that gives you, but, new AFC and new DSS attorney, on a case that had been going on for a long time. There was a default, and they were both throwing fits. I can't, it was an Article 10, it wasn't an Article 6, but it was still, I can't run the default, it's malpractice, my client's gonna sue. Your client's not suing you, you work for your client, whatever, but throwing, and it might not have been Amber, but I think it was, anyway.
Plus your client is a moron.
Throwing a fit, you can't make me run a default on this, and like, even respondents counsel was like, we'll walk you through, we just want this case done with, but how long does it take to get ready for a default?
About 2 seconds.
You don't need 2 seconds, you need a petition and the connection
To
notes.
prepare for it,
Right.
yeah, and you look through stuff.
Yeah.
But everybody's wired differently, like I said,
I had a young trainee who started
Manatee.
Yeah, manatee.
a man.
Manatee who's an ex-manatee now. She's an ex-manatee. Just couldn't, she's a great appellate lawyer, couldn't write, she's smart as hell.
Oh, I know who you're talking about.
But can't handle the courtroom.
Yeah.
She doesn't understand to a large extent, sad but true, something somebody said to me like on my first day of working in the DA's office, sometimes close enough has to be good enough. And
Yeah.
frankly, that's, when you're a trial lawyer, frankly, that's kind of what it is.
And if you're an appellate lawyer, it's precise
Right,
and organized and neat, and you have to be able to go with the flow, you have to think on your feet, you have to learn to
Yes,
read body
thinking on her
language.
feet, I think is her biggest problem, because she needs to sit down and think for a couple of hours
Right.
before she can answer.
but you don't have that time.
You need to pick up on body language from other people, like,
Especially from the judge, when they're like,
Right.
okay, I got you, sit down.
Todd Potter, he's been asking me several times, he tells this story about, he was running a trial with Laval, and Laval kept, telling him, move on, move on, move on.
Yeah.
And he's like, well, no, Judge, because I have to make this point, and she said, but I don't know what point you're trying to make. How can the witness answer the question? She says, I'm the judge, and I don't even know what you're saying. This is essentially what he says. And he's like, this is just me. I said, well, Todd, I've never been in the courtroom when you're making these arguments, but you told me about like 3 different examples where the judges are saying this to you. So you gotta learn to pick up on the body language of the judge and the facial expressions.
But he's so capable of learning, Todd. He has that problem, but
I think he's one of those guys that could be good in the courtroom someday. Maybe he's better at writing and
he needs good training. We don't have, so far, we haven't had a solid training. Now, they break up the issue of notices. We've done Article 10 instruction, it's so much easier right now, because it's right here, and you can make that argument so much better, instead of, you have an instinct, there's something wrong, but you can't grasp on where's the problem. And
So deconstructing the statutes,
I-
all of them,
mine
6,
is
8,
the
and
that,
that
Or
worked out.
maybe-
I only
like
went to a
Russian
few of them,
mentality.
but it was
really
the ones I saw were really good.
so when I'm in my mentality, how I think about this, I think about everything in mathematic terms, like a formula, right?
Yeah.
And then it makes sense. Every single piece of evidence, every single case, it's like different formulas in your head. And I don't know if it's me or is it normal? Like even raise the age. Okay, I think, all right, so first look at the date of birth. Is it AO? Is it JO? Is it this?
Yeah.
Is it that? Next.
Without a-
You look about, okay, next, accusatory instrument, significant injury, this, next. Extraordinary circumstances, next, you know, and it's like, it's little formulas in your head which building up, and then it's so easy. Same thing, Article 10, those arguments, this. And some people get up there and they just talk. But when you think in those formulas, right, you know, let's say educational neglect, well, you need to prove not only the kid missing school, you need to prove that his grades or her grades are a result of missing school, right? So you hear that, and they throw in some other shit, and you're like, what? Like, it has to be a point. You know what I'm saying? And when some lawyers, even great lawyers, but they're all over the place, you're losing that,
Right.
and everything becomes just an argument.
Even the most experienced attorneys would benefit from the deconstructing classes.
Oh, yeah.
Because it's good for the newbies, because it teaches them, you know, the nuts and bolts and the basics, and think about your critical approach to the statute. But we get into, well, it's just the way we do things. This is a bad petition. You know, this is bad. All right, let's reserve our right to a remand hearing so the client thinks we're doing something for them, and try to work out the admission or the menu or whatever. But you know, to take the time and look at some of these allegations, like what you're saying, that's one of the biggest things on an ed neglect, I think, that people miss. And it was my first couple cases were ed neglect, so it was kind of hammered into me, is that their grades are failing as a result. And early on, when I started doing Article 10s, Russell Fox did a motion to dismiss as to his client.
Because the grades probably were still in
He was in the 90s.
Yeah. Remember our Porsche case?
Yeah, that's still going on.
Same. Oh, really? Well, my client's petition is. But what I'm saying is, kind of identical shit. Now they're bringing the substance abuse issue, homelessness issue. But if you look at the nature of this case, there was an ed neglect, and kids are doing perfectly
Well,
fine.
they're not doing fine now.
Oh, sorry. That's the problem with the clients now.
Right.
That's the
Cause we got them ACDs,
You
but
give
your
them
client,
amazing
right.
dispositions and then they fuck it up.
Lavalo, yesterday, I supposed to have a decision on Bob, she asked for 9 months, she said, I will be honest with you, I'm struggling.
Oh, interesting.
That's a win.
That's a win.
I have one.
I'm so trust.
I trust it to you, so keep this in context. I was having a discussion with Judge Susser, with nobody else in the courtroom, about a case I have. And she said, I haven't heard the proof yet. I haven't heard all the proof yet. I haven't made up my mind since the case, the department's case isn't closed, but I don't know that they have neglect.
Wow.
And what we have is a very, very small part of the case. The proof that's still outstanding is a worker from Buffalo Urban League who's worked with my client a few times. And he had nothing to do with the beginning of the case, the neglect itself.
She's been pretty tough on the department. She's dealt with a
Because
bunch of
there's,
things.
she's still mad.
Well, she's pissed about losing Jim Hartman. That's number one. Number two, there's been some pretty awful people going through there and doing awful things. This case I'm talking about, my client is extremely difficult. Jamie Kajobi's the AFC on it. My sovereign citizen guy, if you've heard her talk about that.
There have been a couple of them.
Right. Well,
You know, now navigating from the court system.
he's never called himself a sovereign, he's an indigenous person. He started off by claiming Jamie Kajobi was racist, then kidnapped her kids.
You never found out that her kids are.
He sent her off and saw photos.
I like when people throw those at you, right?
Right.
Clearly not racist.
Right. But, and now he's an indigenous person, and not subject to the jurisdiction of the laws of New York State, et
I've
cetera,
heard
et
about
cetera.
this guy.
He's tried to fire me, 3 times on the record, and he's tried to fire me in the hallway. But we've won 2 remand hearings, and they've asked for, in the middle, after we had testimony on trial, a new SCR or whatever they call them, the report came in So there's a new neglect investigation. He refuses them access to the house. It took them 3 months to do it, but they finally brought an access order. Judge denies it. Kim Kennedy is dumbfounded. Is the judge afraid of him, whatever? I want to say, no, you fucked it up. And that's why she didn't do it, because she didn't do your job. Then, 3 days later, another access order, same language, this time adds another, no, she wanted to do it with another child, because my client's grandson was in there, but the grandchild was not the subject of the initial petition. So she was trying to do the access order as in, we have supervision, they won't let us in, give us an order saying we have access. You already have an order saying you have access, it's the order of supervision.
Right.
From a year and a half ago. And then, so on the record, she says, oh, Judge, the paperwork doesn't seem like it was printed up properly. We'd like to amend the petition, that's already been filed with the court by just writing in the other child's name. I get up to object. Sandra looks at me and she's like, I got this. She said, there's something called the the Family Court Act and the Civil Procedure Law, and I would like you to follow it, and you cannot orally amend this. The proper notice has to be given. And so my guy who's trying to fire me is, beating 2 remand hearings, and it's not me, it's them putting another case. They would have been done a long time ago if it wasn't for Jamie keeping this thing survive. But I was confident I was going to win the remand hearings because they were BS. I've never been confident that I was going to win the neglect.
Right.
But on the remand hearings and in the access orders, the petition says he won't let us in the house to see the children.
It's not even right.
Children. Well, but they wanted to see. So it was Tico. He's not there anymore. You know Tico, African American guy from Africa with an accent.
Oh yeah.
Big, really, really nice guy. Would not tell a lie to save his life. Put him on the stand. Petition says that you haven't been able to get in the house to see the children. That's right. Do you have any concerns with the children? No. Why don't you have any concerns about the children? Because I saw him at school the next day. After I couldn't get in the house, I went to the school and told him. I knew all this. I knew how he was going to answer.
We've talked about it, it's very important to ask the question when you know the answer,
Right.
not the other way around.
Right. I said, so you went and saw the children at school. You talked to them individually. Parent wasn't there because everybody thinks dad is lecturing. These kids are afraid to say anything to Jamie because dad's got them scared shitless. And I said, and you didn't have any concerns? They were well, their attendance is good. They're groomed. They were well dressed. They were clean. Their clothes were clean. All stuff, no concerns at all. So I reminded the judge that not only during the remand hearing, but testimony during the neglect trial, the department has repeatedly said, and of course I'm exaggerating because it's been about 3 times they saw them, but over a year that's repeated. There's never a time when they weren't, when they did have concerns. And there's no concerns. And they had been in the house, they have not been in his house since last summer. But I said, the last time you were in the house, did you have any concerns? No concerns. I said, is there any information you have that would lead you to believe you should have concerns about the house now? No, we're just required to go in there, but you have all the other information you heard, any concerns about the household itself? No.
Why are we there?
Jamie keeps telling me that I'm confusing issues because we have to look back to the neglect petition itself at the time of filing, and that was that he left the kids with mom, and he knew or should have known that she was using drugs.
Yeah, but what proof do they have that he should have known?
The video that the kid took of my client gave to the DSS worker before we were involved. Mom's sitting on the ground, all like Indian style or Native American style, and almost folded in half. She can't sit up, and she sits up and she rocks back down. My client took the stand though. He said, I dropped her off, I didn't look inside, but my son was supposed to be there. He was staying at my apartment. I moved out of the apartment. My adult son was staying at the apartment. I brought the kids over, mom was gonna go over to visit the kids. So the bad thing in the whole case is my client never confirmed and saw that his son was there.
Yeah.
But that's essentially their entire case.
Can you believe we're fighting over that?
No.
He He was non-respondent originally.
But then he didn't open the house, so now he became.
No, I forget what the issue, I think it was when he started calling himself indigenous persons and stuff, that they were worried about his mental health. And so he became a respondent, several months into the case. And Jamie's the one who filed the original neglect. And,
How old is your client? Jamie,
what's it?
how old is Jamie's client?
Like 8, 11 or something like that.
Do they wanna have a chance to be raised in foster home?
If they do, they're afraid to tell anybody.
Then why is she filing?
Cause she's Jamie.
She doesn't like my guy.
I only file either I have an infant or I believe it's
Yeah.
even a
He-
risk of harm.
Um,
Or where your client wants to be, like I literally have a client right now who tells me I'd rather go to foster care than stay at home. And I'm besides myself, what do I do with this? Like my client calls me and says, come to school because he gives me his grandparents' information. He's like, I'll go anywhere, but I won't stay home. But it's like 1 in a million cases where your client tells you, okay, I'll go and live with foster home, just get me out of this house.
Yeah.
And the department filed and wanted to withdraw the petition. So I objected, judge did not let him withdraw. But what I'm saying is, it's like 1 in a million cases, Kevin, when AFC, when you have a kid older to
Well-
do that, so it's interesting.
He had filed a VDOC 2 or 2.5 years before that, before the neglect petition, and he was pro se, and Jamie opposed it, and he lost the default hearing. Because Jamie got him to understand that he gave the ex, pills once. On one occasion, gave her a pill, and he didn't have a chance, because Jamie cuts him off, of course, and as an attorney would do to get your position across, didn't let him keep talking. He said, you wouldn't believe what she was like when she was going through withdrawal. We were taking her to rehab the next day. I gave her a pill to get through the night. And so he knowingly given an addict drugs that weren't hers 2.5 years beforehand. That was part of the basis for her filing.
But
But he causes so many of his own problems with
They
this
all
stuff.
do.
He blows off the appointments that he made to take the kids to go see Jamie. Then he says, "You're not seeing my kids at all." I'm like, "Look, you gotta let her see. You know, there's a court order. I don't follow those court orders." She said, "Well, I do. I'm your attorney. You can argue all your UN stuff or whatever you want." I said, "I'm your attorney in family court, and I'm gonna follow the laws of New York State, and I'm doing my job. And I'm telling you, you have to bring the kids to see her." So she was worried. She said, "I'm only gonna meet them at court now." So he brought him to court. He walks up here, he goes, "Here, girls, this is the kidnapper."
Oh, Jesus.
He tells the girls, "You know, you were removed from my care and mom's care because of this woman. She kidnapped you."
Oh, brother. Oh, should have gone sometime.
So you have a
Yes.
That's why Kevin was so quiet.
I don't have it on me. I can't go into the court building with it on.
Let's go and fight something, fight.
Thanks, Kevin.
Thank you.
We'll see you soon.
Do you have anything in fact check?
No, I'm done. What?
Is there a restroom here somewhere?
It's outside,
Okay.
down the hall.
Thank you.
You're welcome. You did great.
Oh.
You were really good. Do you have time to come down to my office for a minute? Good.
I have my gynecologist appointment.
You're gonna find the records at 4 o'clock, so I have time until 3.
Okay, great. Come down to my office.
So we have all this and we have the last one I just emailed you.
I did, I'll take care of it. I get it out to people. And then I'll come down here and clean this up. I thought that was really good. I thought you did a really good job. I learned a lot. I learned a lot.
I hope so, because I was like, holy moly.
No, you did a good job.
Very nervous.
You're a natural. Thank you.
can play at?
We're having a witness box built also, and it's going to, we just had the guys in today, to, make sure of
You
how
guys
it's
really like to play.
we do like
We really do like to
The
play.
state loves to see
No,
this stuff.
that's how Bob got into trouble.
I know.
It's all this playing just plays outside of the box.
No, but this is,
I know,
Way
this
inside the
is
box.
good.
right, this is good play. I know.
When it spills
I know. I
bad.
know. I know.
It's so easy to blur those lines.
I know.
So easy.
And it's easy to become defensive, and I get that.
Especially when there's
and I get
alcohol
defensive.
involved.
Right, I get defensive, and I know I get defensive, but, you know, what gets me is I'm not really keen on what I view as hypocrisy. So I'm not really keen on that.
In this
You
case,
know.
it's politics.
I understand, but it's hypocrisy. There's pictures all over Facebook of Jen drinking like a fish down at Cartagena in her bikini. And it's like, that's great, I don't have a problem with it. You should be in a bikini, and you should be drinking when you're in
No, as far as
Cartagena.
I'm concerned, the moral of that story is
But don't post it on
shame
Facebook.
on Facebook.
Right, don't post
You're an
post it on
idiot if
Facebook.
you
Right.
do that on
And you're
Facebook.
supposed to have this position as an administrative law judge that
And that would be really
carries some,
good for people
Right.
to find that
Right.
on, yeah.
a parolee.
Yeah. Would
Say,
not be
look,
good.
she judged me. Right? You're telling me to avoid alcohol, but there you are, every single picture.
Yeah,
And
okay, so my
I don't like to
takeaway
pick on
from
that.
that is just because other people do stupid things doesn't mean
Right,
we
and I
should.
agree with you, and I've completely curtailed going out with any of these folks. But here's the other part though, is where does it end? You know, I mean, I
Oh, I
understand,
agree,
I
and you
agree
know,
with them,
it's like
because
saying,
for
and that
28
you can't
years-
go out with people that you're working with,
Right.
but you're working all the time, so you never get to
Well,
go out with anybody.
Yeah, but here's the other part, because then what happens if they say, oh, I see Dan out with Joe Schmo, and he's a panel member, and G. Willikers, he's getting assignments. I mean, where does it end? These are 28 years I've known these people, and I've
I know.
worked with them,
It's a
I've tried
tight-
cases
look,
with them.
There is an adjustment period.
Right.
Ultimately, look, the pendulum goes like this,
I
but
hear you.
it, you know,
I hear
it
you.
slows down eventually. And right now, we are like this.
I know,
Yeah.
and I don't want it to be that
So
way.
that's the most careful time to be, then things will settle down again.
I understand, I understand.
And I think you really have an absolutely fabulous opportunity to show these people what you can do.
Well, you know, and again, it's,
This is the longest interview you will ever have.
And you still have to decide whether you want the job.
Would that be the irony?
Yeah, that would be the irony, wouldn't it though?
Kristen, it's always a pleasure.
Thanks.
Do you need me to hold your stuff while you?
No, I'm good, and I will be in touch, but we're gonna have another personnel committee meeting, then we'll know more details about what we're gonna do, what's gonna happen, and.
All right.
That's a good thing, I know I.
Well, if there's anything that I can do, I know, well, I can tell you this.